Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Asiedu-Antwi. Let me take a minute to thank you for journeying with us for the past year. We started somewhere October 13th and you've been with us up till this point. We say God bless you. Over 4,000 subscribers and spending more than 12,000 hours of your precious time staying on our channel to watch our educative content. We say God bless you and keep journeying with us. We promise to bring you more exciting content and more educative content in the law. It is a laboratory, so we'll take our time to dissect and unpack everything legal. Today our video is proudly sponsored by Nkrumah. They have all assorted food, and if you want to order, their number is on the screen. Trust me, that is what the members of the Law Lab do subscribe to, and we do patronize from them. It is why we are recommending them to you. Today we are looking at Article 75 under scrutiny, whether the action of the government accepting the deportees without a parliamentary approval is constitutional. Article 75 under scrutiny, whether the government action of accepting the deportees from the USA without parliamentary ratification is constitutional. And as such, I will start by giving a context to this conversation for you to appreciate it very well. Now, on the 20th of January, 2025, you know, the American people, the USA, they vote in November and they have the swearing-in ceremony on the 20th of January after every election cycle. So they have about 2 months span for transition. So on the 20th of January 2025, President Donald Trump took the helms of affairs of power in the USA. And what he did on that day, after being sworn in as president, is to sign a number of executive orders. And one of them, if I may refer to, is the Protecting the American People Against Invasion Executive Order. Or that the Protecting the American People Against Invasion Executive Order did was to take out or fish out immigrants or migrants who have overstayed their visa and committing illegal activities in the country out of USA. So that is what the executive order, which is the Protecting the American People Against Invasion, is to do. I am sure you've been reading in the news, you've been watching that there is a certain body the president of the US has constituted called the ICE that is in charge of fishing out these immigrants and deporting them back to their country. This action by President Trump has been met with a number of legal suits. That is not our focus because we are not in the USA. Ours is Ghana, and we are going to deal with how this executive order of President Trump has now affected the Ghanaian people. The NDC assuming power and the President Mahama appointing Minister Samuel Okudzeto Ablakwa, we all realized that one of the days woke up and realized that the US has taken off the 5-year visa duration they mostly grant to our people. And now it became a back and forth conversation. And all we heard was that Minister Ablakwa has now moved to the US, had a conversation with the State Secretary and all the top officials of the US. And we got to know that there has been an agreement, an MoU, a Memorandum of Understanding, being signed between the Ghanaian people or the Ghana as a state and that of the US, that we are going to receive some deportees who are West African nationals. And that after that, quickly we heard that Ghana has again gained the 5-year visa duration that was first stripped off. So it became very topical whether Ghana went in to sign to receive the deportees basically for the 5 years visa duration, and whether that MoU should have actually gone to be placed or laid before Parliament for parliamentary ratification. As we speak now, the MoU has not received parliamentary ratification. And when I say now, I am speaking in the month of October, specifically on the 28th day of October. As of now, we have not received 28th day of October 2025, and as of now, the said MOU has not received any parliamentary ratification. But the big question is it necessary for the MOU, a mere memorandum of understanding, is it necessary for it to receive a parliamentary ratification? That is the big question we are going to answer today. But before that, I want to tell you that on the 4th day of October 2025, Minister Ablakwa, speaking to, I think, Alfred Okansi on TV3's Key Point, admitted to the fact that the agreement he signed, the MOU he signed with the government of US, was to receive the deportees, and it was in the exchange of the 5 years visa duration that was stripped off Ghana and which has now been restored. So receiving the deportees actually gave the Ghanaian people another opportunity to get the 5-year visa duration. Because if we don't get the 5-year visa duration, put political lens aside, it is going to affect businesses, those who have been traveling in and out of America to go and bring goods and sell over here, those who trade, tourists, students, amongst others. It would have been very, very difficult. So that is what Minister Ablakwa actually confirmed on the show.
You want us to relook. Now, they said, okay, you have come to us with what you want. You want us to reverse the visa restrictions. You want AGOA extended. You want us to relook at the 15% tariff. We are also now dealing with immigration challenges. We have all of these people who are in prisons. We are holding them in various ICE facilities. Right. So we want you to help us to deal with this issue. Okay. So I immediately consulted with President Mahama. Then there were cabinet discussions on the matter. Then Ghana said that, look, we are not going to accept Venezuelans, Mexicans, and all of this wholesale deportation all over the place. Within our ECOWAS protocols, our sub-regional legal regime, West Africans can travel without visas to West African countries. So we are going to make the case that, look, if you have some West Africans, in any case, we are not happy that our fellow compatriots are in this distress. They are being held up, they are in cages, they are being dumped elsewhere, places that they are not accustomed to, they don't have relatives, they can't integrate. So we will accept only West Africans under the principle of Pan-Africanism and regional solidarity. So that is how we amended, the U.S. request. And because you notice that
now, after Minister Ablakwa making this public, Democracy Hub has further filed an action before the Supreme Court, demanding a declaration before the Supreme Court that Minister Ablakwa or the said agreement or the said MOU should have been laid before Parliament and for it to gain parliamentary ratification. It is quite interesting because currently, if you look at Article 75 of the Constitution, if I may read, it says the President, 1, the President may execute or cause to be executed treaties, agreement or conventions in the name of Ghana. 2, or Clause 2, a treaty, agreement or convention executed by or under the authority of the President shall be subject to the ratification, A, or paragraph A, by an act of Parliament, or B, by a resolution of Parliament supported by the votes of more than one-half of all the members of Parliament. So the threshold to get the ratification basically is either an act which also goes by more than one-half of all members of Parliament, or by a resolution of more than one-half. Currently, the NDC is having more than 2/3 of the members of Parliament in the current 9th Parliament. And so the question is, why is this agreement being prevented or being shielded from being laid before Parliament for it to receive the parliamentary blessing in the form of ratification. Now, looking at Article 75, if you read, you heard me right, I said a treaty, agreement, or convention. But we had MoU. Now, the question is, does MoU fall within this sort of agreement, treaty, or convention which necessarily needs a parliamentary ratification? That is the question we are all going to answer today. But you see, if you're a law student or you're a law enthusiast, get to know that every provision in the Constitution has its history. It has a historical underpinning, and it is why Sowa Jersey, as he then was in the celebrated case of Tufo, and Attorney General told us that the Constitution shouldn't be construed as a mere act of Parliament, that it is a living organism capable of growth, and it embodies our interests, our history, amongst others. He further goes ahead to tell us that the Constitution has its letter, and same equally has its spirit. Meaning the letter is what I read in Article 75. The spirit is the reason why we have this provision in the Constitution. And today I am going to walk you through carefully for you to understand why we have Article 75. We will add some case laws which will now further affirm or answer the point whether the action of Minister Ablakwa refusing to place the MoU before Parliament for parliamentary ratification is constitutional or not. Now, the first thing is that when you look at the history of Ghana, you know, Ghana gained independence in 1957. So the first constitution ever made in this country, which is, let's say, a homegrown constitution, is the 1960 Republican Constitution. And when we talk of the Republican constitutions, we have only four: the 1960, the 1969, the 1979, and the 1992 Republican Constitution. So Ghana has gone through about four republic status. So the first one, when we say Republican Constitution, maybe when we are not in a democratic, in fact, when we are not in a democratic state, when there is a coup, it means that the said Republican Constitution has been toppled and coup leaders now come in. When we return to what we call democratic rule, then it becomes the Republican Constitution we are going to deal with. So we have four Republican Constitutions: the 1960, 69, 79, and the 1992 Republican Constitutions. But if you pay attention to the 1960 Constitution carefully, you will not find any provision that talks about international relations. You don't actually find a provision. The first time a provision of this sort appeared in our Constitution is in the 1969 Republican Constitution. And if you look at Article 59 of the 1969 Republican Constitution, and if I may read, it is on your screen. It reads, "The President shall, acting in accordance with advice of the Cabinet, execute or cause to be executed treaties, agreements, or conventions in the name of Ghana." It goes ahead to say, two, any treaty, agreement, or convention executed by or under the authority of the President which relate to any matter within the legislative competence of the National Assembly shall subject to ratification by the National Assembly, A, by enactment of an Act of Parliament, or B, by a resolution of the National Assembly supported by the vote of not less than one half of all members of the National Assembly. So clearly, when you look at the provision on your screen and you get to know the first one, Article 59, Clause 1 says that the President shall, acting in accordance with the advice of the Council of States, or of the Cabinet, execute or cause to be executed treaties, agreements, or conventions in the name of Ghana. So the President must, in the 1969, it is not the President who would just wake up, cause a treaty to be executed in the name of Ghana. No, he must act in accordance with the advice of the Cabinet. So first, the President is limited in his action to cause a treaty by complying with the advice of Cabinet. So the first limitation the president faces is to comply or go by the advice of cabinet. The next thing is that the only treaties that needs ratification are treaties which are within the legislative competence of the National Assembly. Now, if you look at the draftsman's report of the 1969 Constitution, it explains the legislative competence to mean that a treaty which ordinarily the National Assembly could have passed into law, then clearly if you go and pass such a treaty outside the country, or when you commit Ghana to such a treaty outside the frontiers of Ghana or on the international plane, then such a treaty needs to be ratified. Example, let's say a treaty on fundamental human rights can clearly be passed by the National Assembly. So if you go and execute any treaty or cause to be executed a treaty, a precedent, when you act in accordance with the advice of your cabinet to cause a treaty to be executed, which is about fundamental human rights, which is within the legislative competence of the National Assembly, then such a treaty needs a parliamentary ratification. So you see, ratification was only limited to laws that could have been passed or that is in the form of the legislative competence of the National Assembly. That is the limitation of in the 1969 Constitution. The first limitation is one: the president must act in accordance with advice of the cabinet. That is the first limitation. And the second one is that ratification was limited to treaties of legislative competence. Now we move from the 69 Republican Constitution, which had Prime Minister Buzia-leading government. Then we transitioned into the 79 Constitution, which had President Dr. Hilary Mann. Now, if you look at the 79 Constitution, Article 62 of the 79 Constitution talks about this ratification. And I want you to listen to Article 62 of the 79 Constitution, and you get to know that it has semblance as that of the 1992 Constitution, Article 75. Now, on your screen, the president may execute or cause to be executed, Article 62(1). The president may execute or cause to be executed treaties, agreement or conventions in the name of Ghana. 2, a treaty, agreement, in fact, let me rest on the one. The president may execute or cause to be executed treaties, agreement or conventions in the name of Ghana. So clearly, unlike the 69 one, which had the president acting in accordance with advice of cabinet to cause Ghana to be executed, or execute a treaty in the name of Ghana. Here, the president goes ahead straight. The president may execute or cause to be executed a treaty, agreement, or convention in the name of Ghana. So the limitation of cabinet advice was taken off in the 1979 Constitution. Now let's look at 2. Article 62, Clause 2 says a treaty, agreement or convention executed by or under the authority of the president shall be subject to ratification by Parliament, and by Parliament, by the enactment of an Act of Parliament, or B, by a resolution of Parliament supported by the vote of not less than 1/2 of all the members of Parliament. So in Clause 2 of Article 62 of the 79 Constitution, you get to know that there was no form of legislative competence. It was opened to include all forms of treaties, all forms of agreements, all forms of convention. You must subject it to parliamentary ratification. And that is the words and the dictate of Article 62 of the 79 Constitution. I want you to pay attention to the 79 Constitution, and as we transition into the 1992 Constitution, I want you to look at Article 75, with a side note, execution of treaties. It says, the president, 75(1), the president may execute or cause to be executed treaties, agreement, or conventions in the name of Ghana. If you compare Article 75(1) and that of Article 62(1), you get to know that the language is the same. Nothing changes. So here in 1992 too, unlike 1969 and like 79, the cabinet limitation has been taken off. Now the president may cause to be executed or execute treaties, agreements, or conventions in the name of Ghana. 2, it says a treaty, agreement, or convention executed by or under the authority of the president shall be subject to ratification by A, Act of Parliament. If you check the 79, it tells you by an enactment of an Act of Parliament. So the enactment has been taken off here by Act of Parliament, or B, by a resolution supported by the vote of more than one half of all members of Parliament. So in the language of 79, it says that by a resolution of Parliament supported by the vote of not less than one half. Here it is saying that by a resolution. In 79, it says by a resolution supported by the vote of more than one half of all members of Parliament. So it is the language that quite differs, but the meaning is the same. You need more than one half of all members of Parliament to ratify the decision. So now the problem we are going to face here is that the Constitution mentions treaty, conventions, or agreements. The question on the lip of every well-meaning Ghanaian who is watching this would ask, the Constitution says treaty, convention, or agreement. Does it mean an MoU is part? Because the Constitution did not mention MoU. Some may even be talking, those in the diplomatic field would even be asking whether note verbals are even part of it. Now, this leads to why the Supreme Court is there to interpret some of these problems or help make a declaration to bring finality to some of these issues we face constitutionally. Now, in the case of Margaret Bamfo and Henry Nana Boakye Esquire versus the Attorney General and Minister of Interior. Margaret Bamfo, I'm trying to get the name well, and it's on the screen. Mrs. Margaret Bamfo and Henry Nana Boakye versus the Attorney General and Minister for Interior. If you care to know, Henry Nana Boakye is the current national organizer of the NPP, And you get to know that they brought an action against the Attorney General when the President Mahama in Mahama #1 administration received a note verbal from President Obama to receive 2 Gitmo Guantanamo Bay detainees to live in Ghana, and whatever the politics around it is not what I'm interested in today. So Mrs. Margaret Bamfo and Henry Nana Boakye brought an action. They maintained an action at the Supreme Court, and their lawyer was Nana Asiedu-Antwi Esquire. Nana Asiedu-Antwi is the legislator or the member of parliament for the good people of Menchia South, and equally the vice chairman of the subsidiary legislation committee of parliament. Now, Nana Asiedu-Antwi advanced an argument in the Supreme Court detailing or chronicling the history behind Article 75, and he believed that from 1969, which had a limited sense, and I've already explained the limited sense. 1, the president was limited by acting on the advice of cabinet, and 2, ratification was only needed for treaties, agreements, or conventions in the form of legislative competence. But if you look at the 79 and the 1992 Constitution, it opened it up. So he argued that he believed that it is the idea of the framers of the Constitution to involve all forms of agreement. The Attorney General, the current Attorney General, the Honorable Dominic Ayine, was the one who appeared. He was then Deputy Attorney General for the government, and he appeared later. The matter was determined post 2016, so in 2017. So later, Madame Dorothy Afriye-Uwa, who was the Chief State Attorney, was the one who continued the matter. So the current Attorney General, then Deputy Attorney General, was the one who appeared in this case to advance arguments. He disagreed with the position, and he made his argument in court. Now, quickly to move on to the ruling of the court. The court clearly stated that the court speaking through Sophia Ekufu JSC, if I'm taking the pain to announce all the members of the panel, we had Sophia Ekufu JSC as she was presiding and later became the CJ who was she presided over the matter, CJ as she then was, Atuguba JSC as he then was, Adinyra Mrs. JSC as she then was, Doche JSC as she then was, Yabua JSC as she then was, and the current acting Chief Justice Bafuboni JSC and Badigbe JSC as he then was, were all empaneled on this matter. And they came out with a majority ruling of 6-1. And it was only Justice Atuguba who dissented in that case. And the majority, speaking through Sophia Ekufu JSC, clearly stated, and I want to quote a portion of the ruling. On page 13, the last paragraph, she says, the language of Article 75 is perfectly clear. The article forms part of the sets of provisions governing the role of the executive arm of government in Ghana's international relations. The scope of the article deals with treaties in general, and the body of the text makes reference to treaties, agreements, and conventions. It is also clear that the instruments referred to relate to Ghana's international relations with other countries or groups or countries. And the article requires that such instruments must be ratified. So she is saying that it is also clear that the instruments referred to relate to Ghana's international relations with other countries, meaning the instrument, the note verbal they were having conversation on, or they were actually arguing or pleading before the court, clearly involve instruments or was an international relations with other countries or groups of countries, and the article requires that such instruments must be ratified by Parliament. So the Constitution makes no mention of any formal distinctions that are dependent on the formality with which such instrument is formatted or brought into being. And so from the aforementioned principles of constitutional interpretation in Ghana, there is no doubt that whereby various forms of documentation, the government of Ghana binds the Republic of Ghana to certain obligations in relation to another country or group of countries, an international agreement comes into existence. Taking into account the substance of the international agreement, taking into account the substance of Exhibit A, we are in no doubt that despite the form in which it has been drafted and the text couched, it is indeed to create an obligation on the part of Ghana to the USA, where inter alia, Ghana binds herself to receive and resettle the two persons and assure that for at least 2 years it goes on and on and on. The very import of the ruling is that the court came into conclusion that in the fact that the agreement has been termed in any name, whichever way it comes, provided it is levying a level of obligation on Ghana, whether it is an MoU, whether it is a note verbal, whether it is a treaty, whether it is an international agreement, a convention, it means that it is an international, it falls within the scope of international relations, and it must fall under Article 75. So the court ruled in that light. So there is a settled law. There is a settled law in Margaret Bamford and Henry Nana Boakye, which clearly speaks that whichever being the document comes, provided that there are some level of exchanges between the countries, which is levying a level of obligation, just as in Margaret Bamford, where the court said that as it is demanding Ghana to receive the two Guantanamo Bay detainees, it means that it is leveling a level of obligation. Put it in a similar context. You go and sign a treaty, or you go and sign an MoU with American people, and you are receiving some deportees from West Africa. The point over here is that it is an international agreement, or it is levying an obligation on the people of Ghana or on the Republic of Ghana to receive some deportees from America. The argument has been that in Ghana, as a West African state, there is a West African protocol. Indeed, there is, or an ECOWAS protocol, which states that the West African nationals can enter into West Africa and stay there, any West African country, and stay there for 90 days. That is correct. But that cannot be contemplated over here when the Minister of Foreign Affairs himself, on the 4th day of October 2025, has testified and confirmed and has vividly stated that the said agreement was signed to receive the deportees so that Ghana gains its 5 years visa duration back. And so clearly it is an international agreement, and it should have been laid before Parliament for parliamentary ratification. Thus, the decision in the Margaret Bamfo and Henry Nana Boakye versus the Attorney General and the Minister of Interior settles it. All forms of agreement, including a Memorandum of Understanding, provided it is levying a level of obligation or duty on the Republic of Ghana, must go through the Article 75 test. Remember, I told you that this video was is proudly sponsored by Nkrumah. They have all assorted food. You can contact them. We recommend them to you. They've been very, very helpful to the team here at the Law Lab, and trust me, their food is very, very delicious. You have their contact on your screen, and this has been the Law Lab. Here we dissect and unpack everything legal. Bye-bye.